Hi, I'm Angel, an attorney with 15 years of experience in AI, cybersecurity, and IP. And today I want to talk about the AI risks that founders don't see until it's too late. AI is eating the world, and all startups have to leverage AI in some form, whether it's in their product or services or in their operation. And of course, that creates a lot of risks that sometimes are hidden and not seen until the decisions are made and we're way down the line, and it's difficult to fix and correct those. One of the biggest risks that comes with using AI models is who owns the model itself and any improvements to the model, confidentiality of any things you put into the model, such as prompt or documents or content, and who owns the outputs of that model. From an IP perspective, a big risk to watch out for is that anything that was written or invented by AI cannot be patented under current law. So as you have people put in different prompts and ideas into the AI system, iterate, brainstorm, and use it to test ideas and assumptions, sometimes that line between the human invention and the AI creation gets blurred. And it's crucial to keep that clean, because to have a copyrightable content or patentable invention, you have to show human conception and human inventorship and human authorship for that. It's a legal distinction that gets pretty fact-specific and difficult. Definitely you should talk to a lawyer with experience in the area that can help you nail it down. They could do for you what is called a human conception audit, which from the beginning tracks all the prompts that you use, the iterations of the idea, and pinpoints really where is that human invention and human conception in the process to make sure that you're actually eligible to patent your invention, for example, or to copyright your code. So that's one of the best ways to address that and make sure that you are good from that standpoint. So we mentioned confidentiality earlier. Unless you're running the model exclusively on site, not connected to the internet, you have to assume that the stuff is not going to be confidential. You have an agreement with that model provider, service provider that spells out some terms. You should definitely know what those are, or talk to a lawyer that can help explain those. But other than that, you should train your people and be very careful what you put in that model, as it is possible for the model to spit out exactly what you put into some of the other users. It actually happened to one big company where the employees put the confidential future product plans for the company into a popular online AI platform. And so another user with a random or clever prompt, hey, if I were company X designing my next product, what would that look like? And lo and behold, the chatbot spit out the exact specs that one of the employees had uploaded to the system. It caused a big stir in the news, obviously, and you don't want to be in that situation ever. So be careful with that. Another big risk of AI is that it gives you the illusion of competence. And so with confidence, it would review agreements, or it will give you templates or language or clauses. Be very careful with that. AI advice is not legal advice. It could hallucinate things. It could give you the wrong advice. It is always best to consult with a competent attorney with experience in that area to make sure that what you're actually doing makes sense and is correct. Finally, when you're writing marketing language with AI, it can sometimes overpromise or say things that are not true and they can get you in trouble. So you always have to have a human review that, and even a lawyer review that, and make sure that you're not doing some false advertising or saying some things that just aren't true and can get you in trouble.